Hello everyone. I want to create a course whereby we learn about income tax and get more context, understand the theory, and be able to become better tax preparers. As AI is taking hold, we will be preparing less tax returns that will be more complicated, doing more consulting. That's where we'll be in 5 years, and I want to take you on this journey. Natasha has been kind to volunteer to prepare these slides. Thank you, Natasha. My idea is to create a 1 hour course that I will present as I'm doing right now, and to have a 1 hour call within each other to discuss the material. So right now we're really talking about the foundation of US income tax, how it came out to be, and the legal framework of it. It doesn't really go into the details that we'll get into shortly, but that's a great place to start. Right, so we will discuss who may practice before the IRS. So these are called Circular 230 practitioners. These are people who can respond to notices and get a power of attorney and act with the IRS when there's an issue. The role of playing research, essential, again, that's what these whole courses will be about. The US tax preparer regulation that is called Circular 230. Those of you who studied for the annual agent exam know what it's about. Annual filing season program is a fancy term for completing some CPE. You don't become a Circular 230 professional by completing those. Essentially, Circular 230 professionals are attorney, annual agents, and CPAs. PTIN requirements, you must have a PTIN to sign a tax return. The US income tax system, US tax law, US tax status, and the layout of a tax return. All right, history. So, yes, originally the US was raising incomes through tariffs and excise tax. During the Civil War, the US needed more revenue, and that's why they created the income tax, which was in place from 1862 to 1872. And that's also when we first had tax preparers, and the annual agent designation was also created during the Civil War in the 1800s. The income tax was repealed in 1872. End of the story. Thank you for attending. Have a good night. Bye. Um, right. In 1913, the Constitution was amended so that the federal government had powers to raise income tax without having to apportion the money based on the population of a given state and without the obligation of remitting that money to the state. So income tax came back and it has been ever more present ever since. You can go on the iOS website and look at the archives. If you look at the 1040s from back then, it was like 3 pages long. There was no schedule, no anything. It was a flat tax rate. Yeah, things have changed. The Internal Revenue Code, that is Title 26. Title 26 is the laws that govern income tax. The F bar is found in a separate title, and that is Title 26 is the law that we, as people who are not attorneys, are allowed to practice. Normally, you need to be an attorney to be able to practice law. The Internal Revenue Code, Title 26, is the part of the law that we can practice as CPAs, EAs, or even tax preparers. Right, and the IRS is tasked with administering the internal revenue code. The IRS mission is to provide America's taxpayer top quality service by helping them understand and meet their tax responsibilities and enforce the law with integrity and fairness to all. As we all know, they are pretty bad at quality service and helping people understand. That's why people come to us and not the IRS. We need to do the work. Wait. Who may practice before the IRS? So again, practicing has a specific meaning, which means communicating with the IRS regarding taxpayers' rights, privileges, and liability, representing a taxpayer at conferences, hearings, or meetings with the IRS, and preparing tax returns, providing a taxpayer with return advice, which has a potential for tax avoidance. Right, so these are the Circular 230 practitioners. These are the people who can practice before the IRS. And I would annotate the previous slide. The caveat is that you only need a PTIN to prepare a tax return. You need to be a Circular 230 practitioner to represent a client before an audit once they have received a notice. Again, Circular 230 Circular 230 practitioners are attorneys who are admitted before the bar in a state or the District of Columbia, CPAs who are qualified in a state or the District of Columbia, or territories, it can be Puerto Rico or the Marine Islands, and annual agent. The remaining two, they don't really exist. There's not many people who are enrolled actuaries or enrolled retirement plan agents, and their ability to practice before the IRS is limited to the matters that they're specialist in. So actuaries, their practice is limited to matters related to section of the IRS within the area of expertise, primary employee retirement plans. Likewise, enrolled retirement plan agents are limited to matters related to sections of the Internal Revenue Code within the IRS expertise, primary employee retirement plans. So again, attorneys, CPAs, and agents can practice before the IRS and have an unlimited right to assist people once they've received a notice to where they've been audited by the IRS. Right. People who are not Circular 230 practitioners can still prepare tax returns, but they cannot represent a taxpayer before the IRS. And they cannot provide services other than prepare a tax return. So anybody with a PTIN can prepare a tax return, but they cannot represent people in the case of an audit. Right, Circular 230 is the circular that defines well, there's a lot of ethical standards. You cannot cash a refund check that a client received from the IRS, even if it's to pay your fees. You cannot charge contingent fees except in the case of an audit. You cannot charge an amount to prepare a tax return that will be based on whether they have tax owing or not. And things like that. It's a lot of fun. Again, if you studied for the annual agent exam, you already studied Circular 230. Right. So the IRS wanted to regulate pay tax preparers a lot more than they ended up being able to. There's the Love versus IRS court case that disband a lot of these requirements, but all US paid tax preparers are required to have a PTIN. Right, you must have a PTIN. I think you could prepare like 10 returns a year without a PTIN. Great. Right. In order to obtain a PTIN, you need to either submit Form W812 or go online to irs.gov/PTIN. If any of you have gotten a PTIN in the past and need to renew it, let me know. Those who don't have a PTIN and are not sitting for the annual agent exam don't need it because I'm signing the returns. As far as the IRS is concerned, I prepare the returns. I'm responsible for your work, which is why they need to be accurate. Right. It can be completed online at irs.gov/PTIN, and you would either provide a social security number or some other way to confirm your identity. If you don't have a social security number, you go to the US consulate to get a notarized copy of your passport. Right. The Interrevenue Code Title 26 is administered by the IRS. In Canada, it's the CIA. And there are several categories of taxpayers as they're defined in IRC 7701 if you're interested. And essentially we have US persons, which would be either US citizens, people who meet the substantial presence test or the green card test, and non-resident alien, who are people who are not US persons. Right. I don't have to remind you what a 1040 looks like. Um, so we used to have 2 pages, and then we had forms and schedules with letters. And the first Trump administration created a postcard Form 1040 so that you can have a tax return that fits on half a page, except now to shorten it, he had to remove information. So now pretty much anybody needs to complete the schedules with the number, schedule 1, 2, 3. And so the 1040 is shorter and we have more schedules, which makes the whole thing longer. But that's what the first Trump administration did. Right, we spend a lot more time at some point on doing research. So first, I want you guys to understand the tax law, but at some point, the next step will be to, instead of relying on what I tell you or what some attorney is telling you, to go directly to the Internal Revenue Code regulations and judicial decisions to make have an opinion for yourself. So the Internal Revenue Code is the law. That's what we're complying with. Oftentimes, Congress didn't want to get into details and trusted the IRS to implement the Internal Revenue Code. So in the Internal Revenue Code, it will say you will need to comply as per the regulations to be drafted by the Department of the Treasury, which leaves the door open for the IRS to issue regulations. So the IRS can issue regulations either when the Internal Revenue Code is not clear, and then you can dispute it and argue the Internal Revenue Code was clear and the regulation is not valid, because you always need a law to have a tax position. Even the IRS needs to have a law to back up its position. But when Congress in the Internal Revenue Code said to be implemented as per the regulation, then the IRS is free to do as they want with these regulations because that's what the Internal Revenue Code said. And finally, judicial decisions. That's when you go to the tax court or another court. That's the situation we have with the penalties on Form 5471 right now. there was a court case that said that the IRS didn't have the authority to assess penalties, and that was, you know, it became law essentially. The way the court interprets the law is the way it is to be interpreted unless and until another court was to interpret it differently, which happened. So now we have two different interpretations for those who are within Washington, D.C.'s jurisdiction, which sadly is everybody with a foreign address, and people who live in other jurisdiction of the tax court. Again, I'm referring to the penalties on Form 5471. If you have a late Form 5471, can the IRS assess the penalties through administrative means as it does? All right, that's all I'm going to say about it. Feel free to contact me if you want to know more about penalties for Form 5471. Right. Um, right, so the primary authorities are what we saw in the previous slide. That's really the authoritative source. And then your secondary authorities, which can kind of fill in the blank when you're still unsure of a position, but they're secondary. If a matter is being addressed by a primary authority, then the secondary authority is not valid. So, for instance, the publications, the instructions to the firms are secondary authorities. If the IRS says something that is incorrect in the instructions to the firm and you follow it, they could still disagree with you and assess penalties because you didn't comply with the interrevenue code. You just followed what they said. It's pretty rare, but a lot of topics are very complicated, and there has been instances in which the instructions to the firms were incorrect. It's rare, but it happens, and when it happens, you cannot just claim reliance on the instructions to the firms. Right. Right, so forms and publications are the ways the interview code implements the in, the iOS interview service implements the interview code. Right. Beautiful. Um, right, beautiful. I look forward to having more of these sessions with you guys. And feel free to contact me so that we can make this better, whether someone wants to volunteer to make a presentation or if you have some feedback based on the topic you want to see or anything else. I want these courses to be as interactive as possible. Thank you again.